Let's be real. Workplace disagreements are a total nightmare. Doesn't matter if you're an employee or the boss. But when things get serious in India, you're not just left to figure it out on your own. There's actually a formal legal roadmap designed to solve these exact problems. And today, we're going to walk you through it. So picture this. You're in a serious conflict at work. Maybe it's about your pay, your safety, or you've been suddenly let go. The massive question is, what actually happens next? Where do you even start? Well, the good news is you're not navigating in the dark. There is a structured legal roadmap designed to guide everyone involved. So let's start at the very beginning of that road. Okay, before any lawyers or officials get involved, the first stop on our roadmap is always direct communication. The law actually wants you to try and solve things internally first. And believe me, there is a smart way to go about it. It's a pretty logical flow, right? You start by calmly figuring out what the actual problem is. Then, and this is key, you actively listen to the other side's point of view. After that, you gather objective facts. We're talking contracts, emails, that kind of thing. And only then do you start trying to find a solution together. Honestly, if you can get this part right, you might not even need the rest of the roadmap. But of course, talking doesn't always work. When a simple conversation hits a brick wall, that's when India's formal legal process kicks in. And the core of this entire process, it's one key piece of legislation, the Industrial Disputes Act. Think of it as the official rulebook for our entire journey. Its whole purpose is simple but really powerful: to provide a fair and peaceful way to settle these kinds of conflicts. It's not about pointing fingers or finding blame. It's about preventing huge disruptions and making sure there's justice for both sides. And to really understand this law, you have to understand the year it was born, 1947. Just think about it. In the 1940s, right after World War II, India was dealing with massive economic strain and a ton of labor unrest. The old laws just weren't cutting it. So, right as the nation itself was being reborn, this act was passed to create stability and industrial peace. And what's incredible is that it's still the cornerstone of Indian labor law today. All right, so what does this official path actually look like? Well, the Act lays out a formal, multi-stage process that's specifically designed to resolve issues before they blow up into a full-blown courtroom battle. It really boils down to two main stages. First, you have conciliation, which is basically mediation. And if that doesn't work, the dispute can move on to adjudication, which is the more formal, court-like step. So that first step, conciliation, brings in a neutral government-appointed officer. Now, their job isn't to pick a winner or loser. It's to investigate the facts and actively guide both the employer and the worker toward an agreement they can both live with. And this first step is incredibly effective. Get this, over 70% of all disputes are settled right here during conciliation. That just goes to show you this system is working the way it's supposed to. It's a path that successfully resolves the vast majority of cases without ever having to see a judge. But what about that other 30%? Well, if conciliation fails, the officer files something called a failure report. From there, the government can officially send the case to a labor court or an industrial tribunal for a formal binding decision. So once the whole process is complete, what does the final legally binding outcome actually look like? There are two key terms you need to understand here: settlements and awards. The difference really comes down to who's in the driver's seat. On one side, you have a settlement. That's the mutual agreement you reach during that mediation stage. It's a binding contract that the two parties create themselves. On the other side, you have an award. This is a decision that's made for them by a judge. It's a binding court order. So the crucial difference is who makes that final call, you and the other party, or the court. So you see, this is so much more than just a dry legal process. This act serves a much deeper purpose. It's actually one of the most important pieces of legislation for protecting the rights of workers all across India. I mean, the protections it offers are immense. It gives you a legal shield against being fired unfairly and a clear path to get your money if wages are withheld. It strengthens the power of unions and collective bargaining. And this one is huge. It safeguards workers from retaliation. Your boss can't just change your working conditions or punish you because a dispute is ongoing. This quote really just sums it up perfectly. The act is a vital shield. It helps level that huge power imbalance between a big company and a single worker, giving them real access to justice without the crazy high costs of a typical lawsuit. And that brings us to our final thought. The Industrial Disputes Act was born from the challenges of 1947. But as India's economy is totally transformed, with gig workers, remote jobs, and brand new industries, the big question remains: does this 75-year-old roadmap still point the way forward for today's modern workforce? Definitely something to think about.